This is a podcast on Section 8 orders, and it is part of Study Unit 4 for the Distance Learning course 2020. Section 8 orders are made in respect of children, usually when people with parental responsibility or other adults who have an interest in the child's life, or perhaps the child themselves, have some form of disagreement about some aspect of the child's life and upbringing, and the court is effectively asked to intervene and to resolve the dispute which is going on. As we will discuss, there are 3 orders contained within Section 8. Child arrangements orders, specific issue orders, and prohibited steps orders. As we will discuss more in a few moments, each one of them has a different practical purpose, and when you come to approach a problem question, you need to consider what is it that the person or people you're asked to advise are trying to achieve in the situation you've been given in the scenario. It's important to note as well that the orders can be combined if a court thinks that's appropriate, so it isn't always a case of picking one of the 3 orders and excluding the other 2. It's also important to note that the orders are designed to be flexible, and the courts are able to attach conditions and directions when making them. See Section 11(7) of the Children Act 1989. We are going to consider each one of the different orders in turn, and the kind of circumstances in which it might be appropriate for such an order to be made. First of all, there is the Child Arrangements Order. This was introduced into the Children Act in 2014 by Section 12 of the Children and Families Act of that year. It replaces the old Contact and Residence Orders, which had been key features of the original Section 8 framework in the 1989 Act. Of course, contact and residence themselves were terms which had been intended to, and in fact did, replace custody and access. You can see that there has been a progression in the law from a situation in which children were treated almost as quasi-property to one in which children are now seen as being at the centre of the process, and also the emphasis is on making a practical decision to sort out a situation or a problem which has arisen, and to try to get away from the sense of there being winners and losers. An adult has been awarded something and sees this as some sort of prize for themselves. Obviously, how successful this will be still to a degree remains to be seen, and there are valid questions about how far changing the terminology is going to change the outlook and behaviour of people involved in legal battles around children. But that at least is the thinking and the logic behind the change in terminology. Child arrangements orders cover matters which used to be within contact and residence. So they regulate with whom a child is going to live, spend time, or otherwise have contact, and also when those things are to happen. If you are dealing with a problem question and issues arise around where the child is to live and whether they're supposed to spend time, have contact with a particular adult, then you must use a child arrangements order to deal with those matters. Anything else would simply be incorrect. And it also matters a lot because the people who can automatically apply for a child arrangements order, as we'll see, without needing to seek leave from the court, are not the same as the list of people who can automatically apply for the other 2 sorts of orders. So the distinction between a child arrangements order and also between specific issue and prohibited steps orders is a very significant one. Next up, we have the prohibited steps order. These cover matters which ordinarily could be dealt with by a parent. So literally a step which could be taken by a parent in meeting his parental responsibility for the child. And in these circumstances, that step is prohibited and it cannot be taken by any person unless they have the consent of the court. So it puts a block on a course of action which could otherwise legitimately be taken by a parent from being taken. And then finally, we have the specific issue order. This is a case where there is some concrete decision about which agreement cannot be reached, and the court is effectively asked to give directions and to resolve the dispute. And it can be in connection with any exercise of parental responsibility. Although do bear in mind, as I said, if you're dealing with where the child should live and which adults the child should spend time with, then you don't use a specific issue order. Those matters belong with the child arrangements order. But any other matter in the orbit of parental responsibility would be covered by this order. Although in some circumstances the courts do have power to make Section 8 orders on their own motion in family proceedings, most of what you're going to be concerned with in terms of your assessment relates to an application, somebody going to the court and requesting a Section 8 order. And if you're dealing with that in the context of a problem question, the first thing you need to decide is which of the orders is appropriate in these circumstances. Once you have decided which order is appropriate, you then need to ask, is the person I'm advising automatically entitled to apply for this order, or are they going to have to seek leave from the court? And you can find the answer to this within Section 10 of the statute. And this is an area where I really would emphasise it's important that you go to the legislation and you look directly at the wording of the legislation. Do not rely on a summary which you have read, even in a reliable source like a textbook. Please go back and look at the legislation and the words contained in it. It's quite subtle sometimes, and if you don't do that, you run the risk of making a mistake. The reason why some people need leave and others don't is that the legislative framework takes into account the fact that it's potentially quite problematic to have external people who are not immediately involved in the child's life as of right, if you like, coming along and intervening in the exercise of parental responsibility by the parties in whom it's been vested. So in one sense, the person has to demonstrate why it's appropriate that they should have some say, some involvement in this child's life. On the other hand, the reason that it is possible to seek leave successfully is a recognition that people other than those who automatically have parental responsibility or have acquired parental responsibility might have a legitimate interest. It might be beneficial for the child and for them if they have some voice in the child's upbringing and indeed, in some circumstances, acquire parental responsibility. As I've already mentioned, the list of people automatically entitled to apply for a child arrangements order is different from the people who are automatically entitled to apply for the other two orders. You need to look at Section 10(5) in respect of the child arrangements order, and also where the specific elements of with whom a child is to live are concerned, Section 10(5)(a) and (b). When you're dealing with one of the other two orders, you need to look at section 10.9. Note as well that a child applying for a Section 8 order in respect of some aspect of their own upbringing needs leave as well, and in that case you need to look at section 10.8, and you also need to be familiar with the case law on this, and I would refer you to the materials for weekend number 4 on the Learning Room, and also the section in the textbook is very good on this. So in summary, if you're dealing with a problem question involving Section 8 orders, these are the questions which you should consider in order to give yourself a structure to answer that question. Firstly, which of the Section 8 orders is going to be appropriate to resolve the problem with which the person you're advising is concerned? So which order do you need? Secondly, does the person who is applying need to seek leave, or do they have an automatic right? Thirdly, if yes, they do need leave, then you need to consider the relevant factors in whether or not that leave will be granted, particularly looking at the case law. And then finally, you need to look at whether or not the actual order itself might be granted, assuming that the person obtained leave. Obviously, you always want to do that, because if you conclude that the person definitely would not get leave, then you're going to have to stop writing, and you clearly don't want to do that when you still have scope to demonstrate your understanding and to gain more marks. The dominant consideration, as you would expect, in deciding on making a Section 8 order is the welfare principle. However, again, it is also important that you are properly familiar with the case law that might arise or relate to particular circumstances. So if, for example, you have a problem question about a male child and circumcision, then you need to be familiar with the case law on ritual male circumcision. Spoiler alert on that topic. To date, there has never been a reported case in which a court in England and Wales has granted a specific issue order for ritual male circumcision where one of the parties with parental responsibility has objected to the operation being performed, which does not say that it is completely impossible, but it is very unlikely that that particular order would be granted. Clearly, that is going to be an extremely relevant consideration if you were addressing a problem question and ritual male circumcision came up. So you do need to be familiar with the specific case law and whatever it is you're talking about, whether it's a child wanting to live in a different household from their parental home, or wanting to change a school, something along those lines. Also, as well as the case law and the welfare principle, you need to be aware of two other general principles. One of them is the principle of no delay, which is intended to do pretty much what it says on the tin. And the other is that of no unnecessary order. So the court will not step in with a Section 8 order unless it is persuaded that that is required by the circumstances. If the court believes that the parties are capable of appropriately resolving the matter, then there will be no order made. I hope that that brief overview has been useful. Obviously, as always, feel free to contact me by email if you have any questions about this or any other aspects of the learning for this weekend. Thank you very much.